Finishing up the Equal Credit Opportunity Act out of the Reference Guide to Regulatory Compliance in the electronic version, page 114, and the paper version 95. I'm in Subpart G, providing appraisals and other valuations. The general rule is that a creditor must provide an applicant with a copy of all appraisals and other written valuations developed in connection with an application for credit that is to be secured by a first lien on a dwelling. The term valuation includes any estimate of the value of a dwelling developed in connection with an application. This rule applies to applications that are denied, withdrawn, or incomplete. 2. Appraisals and valuations must be provided promptly upon completion or within 3 business days prior to consummation, whichever is earlier, for closed-end credit, or account opening for open-end credit. 3. The applicant may waive the timing requirements and agree to receive the property or the copy at or before consummation or account opening, unless otherwise prohibited by law. Waivers must be in writing and received at least 3 business days prior to consummation, except for clerical changes to a previous version of an appraisal or valuation that was provided at least 3 business days prior to consummation. If the account is not consummated, the creditor must provide copies no later than 30 days after the creditor determines that consummation will not occur. 4. Disclosure requirements. A creditor must mail or deliver to an applicant not later than the 3rd business day after the creditor receives an application for credit that is to be secured by a first lien on a dwelling, a written notice of the applicant's right to receive a copy of all written appraisals developed in connection with the application. B. In the case of an application that is not to be secured by a first lien on a dwelling, but the creditor later determines that the loan will be secured by a first lien on a dwelling, the creditor will mail or deliver a disclosure not less than the 3rd business day following the day the determination is made. What am I talking about? Disclosure requirements. A creditor must mail or deliver to an applicant not later than the 3rd business day after the creditor receives an application for credit that is to be secured by a first lien on a dwelling, a written notice of the applicant's right to receive a copy of all written appraisals developed in connection with the application. The rest of the stuff is odd. In the case of an application that is not to be secured by a first lien on a dwelling, but the creditor later determines that the loan will be secured by a first lien on a dwelling, the creditor will mail or deliver a disclosure not less than the 3rd business day following the day the determination is made. No. A creditor will always do this. There won't be a circumstance where there's some sort of an exception based on collateral. 3rd, only one disclosure is required when there are multiple applicants. It must be given to the primary applicant when one is readily apparent. Reimbursement. A creditor may not charge an applicant for providing copies of appraisals and valuations, but may charge a reasonable cost for obtaining the appraisal or valuation. Letter H, furnishing credit information, account designation. Creditor must designate any new account to reflect both spouses if both are contractually liable or are permitted to use the account. And under account designation, must designate any existing account to reflect the participation of both spouses within 90 days after receiving a request. 2. If credit information is provided to credit reporting agencies, it must be transmitted in a manner that allows access to information in the name of each spouse. And 3rd, if credit information is furnished in response to inquiries concerning an account reflecting the participation of both spouses, the report must be furnished in the name of the spouse with whom the information was requested. Letter I, self-testing. A bank may engage in voluntary self-testing and self-correction if its compliance with Reg B. If the bank takes any appropriate corrective action, the report's results, analysis, opinions, and conclusions of the self-test will be protected by privilege. The privilege will be lost if the information is voluntarily disclosed to the government or the public, or is used in any manner as a defense to a discrimination charge. 2. A self-test is a program practice, or study that is designed and used to determine the extent or effectiveness of a creditor's compliance with ECOA or Reg B, and creates data or factual information that is unavailable and cannot be derived from loan application files or other records related to credit transactions. Self-testing protective privilege does not apply to information about whether a self-test has been done, the methodology or scope of the self-test, the time period covered, or the date it was conducted, or B, loan application files or other records related to a credit transaction and information derived from such files and records, even if it has been reorganized and summarized for analysis. 4. Corrective action must be taken when the self-test shows that it is more likely than not a violation occurred. B, must be reasonably likely to remedy the cause of the violation, and C, may include both prospective and remedial relief. Record retention of applications. The bank must keep for 25 months from the notification of action taken the following items: applications, B, notices of action taken, notices of incompleteness, and statement of specific reasons for adverse action. C, any statements from applicant alleging a violation of ECOA or Reg B, and any information required for government monitoring purposes, which generally would be on the application. 2, existing accounts must keep for 25 months from the date of notification of adverse action the following items: written information concerning the adverse action, written statements submitted by the applicant regarding a violation of ECOA or Reg B, and other applications. Applications that are not subject to the notification requirements for consumer credit must be kept for 25 months, and all other written information concerning the applicant must be kept for 25 months. Business credit applications for businesses with gross revenues of $1 million or less must be kept for 12 months, and business credit applications and documentation for business with gross revenues of more than $1 million must be kept for 60 days unless the applicant requests specific reasons for action taken, in which case the documents must be kept for 12 months. For 25 months after a self-test has been completed, the creditor must keep all written or recorded information about the self-test. Pre-screened solicitations. Creditors must retain for 25 months after the date that an offer of credit is made, 12 months for business applicants with gross revenues of $1 million or less, the following items: A, B, or C. A, the text of any pre-screened solicitation. B, the list of criteria used to select recipients. And C, any record of complaints regarding the solicitation. 6, in any event, if notified that it is under investigation for an alleged violation of ECOA or Reg B, the creditor must keep all documents until final disposition of such investigation or proceeding. Enforcement. Civil liability includes actual damages and punitive damages, which can be $10,000 in individual cases and or the lesser of $500,000 or 1% of the creditor's net worth in class action suits, and lastly includes attorney's fees. Under FIRA, the Financial Institutions Reform, Recovery, and Enforcement Act, the penalties are your usual $7,500 per day. For violations, $37,500 per day. Violations are unsafe or unsound practices are engaged in recklessly or are part of a pattern of misconduct that causes more than a minimal loss to the bank or any pecuniary gain to the parties involved. And third, penalties up to $1.425 million per day against persons who knowingly commit a violation or knowingly and recklessly cause a substantial loss to the bank or a substantial benefit to the party. Administrative enforcement, lastly, involves 1, 2, and 3. Cosigners who are improperly required must be released from liability, may require the correction of discriminatory practices by adopting a program to overcome the effects of discouraging applicants or inviting unfairly denied applicants a chance to reapply for credit, and may require new adverse action notices be sent if institution fails to properly send such notices. There's probably a sample here. Okay, there's a sample of notice of action taken and statement of reasons. What's this? Okay, this is with a counteroffer. the model credit score notice, which was completely not discussed in the text. And what I would have expected to see was the right to copy of an appraisal, but you can't get everything you want.